Hello everyone. Alright, so since we have another issue with filming from a public sidewalk outside a military base, there is another case that I sort of stumbled upon when I was going back over my reviewing of United States versus Appel there. And so that is Flower v. United States, 407 U.S. 197, 1972. But before I start reading this, there's also a CFR, or I mean not a CFR, a federal regulation that you'll hear cited quite often with these cases. That is 18 U.S.C. Code 1382, entering military, naval, or Coast Guard property. And it states, whoever within the jurisdiction of the United States goes upon any military, naval, or Coast Guard reservation, post, fort, arsenal, yard, station, or installation for any purpose prohibited by law or lawful regulation, or whoever re-enters or is found within any such reservation, post, fort, arsenal, yard, station, or installation after having been removed therefrom, or ordered not to re-enter by any officer or person in command or charge thereof, shall be fined under this title or imprisoned not more than 6 months or both. And this is pretty much the law or regulation that they would use to deal with people that are trying to gain access to closed military bases. And yes, there is a difference between a closed and an open military base. We'll get into that here with this case. And people that have been barred from entering a military base or any of these issues right here. And so let us go ahead and look at Flower v. United States. Application of 18 U.S.C. 1382 prescribes the re-entry onto a military post of a person who has been removed therefrom or ordered by an officer not to re-enter. Held violate of First Amendment rights as applied when a petitioner, a civilian who had previously been barred from the post, was arrested after re-entry while quietly distributing leaflets on a public street, extensively used by civilians as well as military personnel that runs through Fort Sam Houston, an open military post. Now here's the key part for this. A public street used by both civilians and military personnel that runs through Fort Sam Houston. This is literally on an open military post. Now let's go ahead and continue on. Petitioner John Thomas Flowers, a regional peace education secretary of the American Friends and Service Committee and a civilian, was arrested by military police while quietly distributing leaflets on New Brunflet Avenue at a point within the limits of Fort Sam Houston, San Antonio, Texas, in an ensuing prosecution before the United States District Court for Western District of the United States on the charges of violating 18 U.S.C. 1382. Whoever re-enters or is found within a military post after having been removed therefrom or ordered not to re-enter by any officer or person in command or charge thereof shall be fined not more than $500 or imprisoned not more than 6 months, or both. It was established that the petitioner had previously been barred from the post by order of the deputy commander because of alleged participation in an attempt to distribute unauthorized leaflets. The district court found that the 1382 valid law was validly applied. Sentenced petitioner 6 months in prison. A divided panel of the Court of Appeals of the Fifth Circuit affirmed. Reverse whatever power the authority may have to restrict general access to a military facility. See, this specific court case where the fort commander chose not to exclude the public from a street where petitioner was arrested, as Judge Simpson dissenting below noted. There are no sentry point or guard at either entrance or anywhere along the route. Traffic flows through the post on this and other streets 24 hours a day. A traffic count conducted in New Brunflet Avenue on January 22nd, 1968 by Director of Transportation of the City of San Antonio, shows a daily 24-hour vehicular count of 15,110 south of Gray Street. This place where the street enters the post boundary at 17,740 vehicles daily north of that point. The street is an important traffic artery used freely by buses, taxis, and other public transportation facilities, as well as by private vehicles, and its sidewalks are used extensively at all hours of the day by civilians as well as military personnel. Fort Sam Houston was an open post. The street, New Brunswick Avenue, was completely open street. Now, here's the part where you see open post. 452 FD at 90. Under such circumstances, the military has abandoned any claim that it has special interest in who walks, talks, or distributes leaflets on this avenue. The base commandant can no more order petitioner off public streets because he was distributing leaflets than could the city police order any leafleter off a public street. Lovell v. City of Griffin, 1938. And then another case in 1939. Streets are natural and proper places for dissemination of information and opinion. One who is rightfully on a street which the state has left open to the public carries with him there, as elsewhere, the constitutional right to express his views in an orderly fashion. Jemison v. Texas, 1943. The First Amendment protects petitioner from application of 1382 under the conditions like those of this case. Accordingly, without the need to set the matter for further argument, we grant the petitioner a right of, I'm not even going to try to pronounce that, and reverse the conviction. Reversed and remanded. So, we'll get into the dissenting opinions down here. But as you can see, this was on a military base that's open. And this specific case law right here would also apply for people that are doing filming on a public street that's on the edge or boundary of the military base where there is a public roadway used by everybody. And so, as Junkyard News pointed out in his other thing, that the issue was about a contractual kind of thing for easement. Yes and no. We have established case law prior to that, because this is actually how I found this case, was by going back over the Appel case, and I noticed they were referencing a Flower case. So I went and looked up this one, and it turns out that this not only would apply to freedom of speech, but freedom of press of gathering information, as long as it's open to the public in this kind of situation. Now, when the main thing that the Appel case was arguing was the issue of a specific person being barred for prior actions that could be readdressed, and that's actually going to be covered in the dissenting part, which is going to be the interesting part. Whoops, I must have skipped past that. Let's go back up here. Where is it? Here it is. Okay, and now we're going to look at Mr. Justice Blackman's dissent, along with Mr. Justice Rehnquist, I think that's how you pronounce it. Dissent for who would be grant this petition for criteria, and here the argument of the merits. Okay, let's start reading this. The result, if not reasoning, of the court's impersonistic summary reversal of the Court of Appeals in this case is clear. Without benefit of briefs or oral argument, the court declares unconstitutional this application of 18 U.S.C. 1382, a statute enacted to give commanders of military posts authority through thought necessary by Congress to exclude civilians from post area after proper notice. Because the post commander of Fort Sam Houston may have permitted civilian vehicle and pedestrian traffic on New Brunswick Avenue within the limits of Fort Sam Houston, the court holds that he has abandoned any claim of special interest in who walks, talks, or distributes leaflets on the avenue. Obviously, the court cannot be referring to the subjugative intent of the base commander, since he gave no petitioner due notice of his disbarment from the base and bringing of his prosecution evinces or rather strong interest on the part of the commander in the petitioner's leafleting activities. If the court means to say that once any portion of the military base is opened up to unregulated vehicular traffic, it automatically follows that such portion of the base acquires the status of public square in a city or town, mere statement of that proposition, which is all that is contained within the court's opinion, is not a self-demonstrating, not self-demonstrating. Since the court does not hold, and it does not appear on record that it could hold that the petitioner flower was treated differently from any other leafleter, the court holding does not deal with any possible denial of equal protection. The case getting tongue-tied here. The case thus concerns only First Amendment claim of leafleters to go anywhere on military bases to which civilian vehicles and pedestrians are granted free access. Which, that is true. That's what this has done. This doesn't just apply to leafleters. It applies to anything when involving civilian access to not just military bases, but certain other situations, government buildings and stuff like that. Anderley v. Florida of 1966 suggests that civilian authorities may draw a reasonable distinction based on the purpose for which public buildings and grounds are used, and according to the right of exercise First Amendment freedoms in such buildings and on such grounds. Simply because some activities and individuals are allowed on government property does not require the abandonment of otherwise allowable restrictions on its use. Indeed, it's generally recognized that demonstrations on courthouse grounds can be prohibited in order to protect proper exercise of judicial function. See Cox v. Louisiana of 1965. See also statutes 617, 640 USC 13K prohibiting any demonstrations on grounds surrounding this court, similarly to unique requirements of military. Of morale and security may be, necessitate control over certain persons and activities on the base when even while normal traffic flow through the area can be tolerated. The court opinion leaves the base commander with the Hobson choice. He may close access to civilian traffic on New Brunswick Avenue and other traffic arteries traversing the post, thereby also causing substantial inconvenience to civilian residents of Baxter County who presently use these arteries, or he may continue to accommodate the convenience of the residents, but only at the cost of surrendering the authority Congress conferred upon him under 18 U.S.C. 1382 to control access to the post he commands. And an additional problem to which the court opinion devotes no attention whatever is the question of whether the petitioner should be free to challenge the validity of the post commander's original debarment order in defending a criminal prosecution under 18 U.S.C. 1382. The Solicitor General, in opposing the petitioner of the writ of Courtier, I think that's how you pronounce it, right, contended that the petitioner would have been free to challenge the disbarment order in reading separate proceedings in the United States District Court relying upon Kalinsky v. Nichols, 1970, and Dash v. Commanding General, 1970. The court, by determining sub silento, I'm not sure how to pronounce that, that exhaust of such remedies is not required, substantially duties the effectiveness of the criminal sanction that Congress deliberately placed behind a post commander in order of debarment. It is accomplished of the dilution in a way that may not be all that necessary to the vindication of the petitioner's First Amendment rights by requiring petitioner to proceed in an orderly manner to first litigate any alleged constitutional infirmity in disbarment order of the court, could assure him a forum for the assertion of such claims while preserving to the post commander the availability or relative summary criminal action against one who violated the debarment order whose validity has not been contested, while while full argument in this case on the merits might persuade me that the court's result was required by the Constitution, it presents an opinion certainly has not done so. I therefore dissent from the summary reversal. And a little note here, from the record consenting largely from a recording consenting largely of recorded officers of proof, the court concludes that Fort Sam Houston was an open post. It also concludes that New Brunswick Avenue, a traffic artery within the post, was completely open street, presumably more open than the post as a whole. While I have difficulty at this stage of the case knowing that the court reaches these factual conclusions, or indeed what exactly the varying degrees of openness are meant to connotate, my disagreement with the court summary reversal is not limited to this aspect of the case. So there we have it. Pretty much what the latter part of the argument here was, that this should have gone through the appeals of the disbarment issue first, and that should have actually been the route that this was dealt with, but the court did not address that specific issue with the opinion. Part of the reason why the these two justices disagreed with the specific issue on this. But I will definitely have a link to this court case here, so that way you can look it up yourself. And I have to say that this right here gives a little bit stronger grounds for filming from areas like when I did the J-Bear case and when I filmed the various military bases down there in San Antonio, where I was generally standing on public streets or the public sidewalk where there's a public right-of-way. Even though the military base may have coverage over that spot, or the base grounds goes over it, it is strict. I mean, it is very open where everybody's able to use that 24 hours a day. And especially with the one Air Force base where I was standing, that street was used by the majority of the public. There was no restrictions on it going through that area and all that stuff. And the same thing can be said and applied to what's going on with Junkyard News and Silent Citizen. And for me, I would love to tackle these case issues, but currently I am also dealing with the U.S. Marshals, which I am actually supposed to be getting some rest right now and get ready for a legal meeting, wink wink nudge nudge, but there will be more about that in the future. And as is, I'll leave off with all of this. Please let me know what you think in the comments. If you have anything more to add on to this, or do you not like my opinion or conclusion of this, or what the court is, go ahead and put that in there. I always love reading some of the discussions on these legal issues more, and hopefully I'll be able to cover more of this later on.